Thank you for joining us today for today's webinar episode, Preparing for an Arbitration. My name is Jeff Zano, and I'm your moderator. This webinar is part of the Financial Poise Alternative Dispute Resolution webinar series. Slide 8 will show you the rest of the series. I think we have one more coming up on July 22nd. Okay, and slide 6 provides a summary of what we've been going over, or what we're going to go over today. Speaking of the slides, you should understand from the get-go that we may not go through all the slides, nor will we go in order, so just keep that in mind. This webinar, like all Financial Poise webinars, a conversation that we will have with our esteemed panelists. Keep the PowerPoint handy, however, because I will try to indicate from time to time what slides our conversation is touching on as we proceed, so you can take notes. Slide number 4 has our disclaimer. I'll show you that. Please note that our PowerPoint is for informational purposes. It should not be considered legal, financial, or other professional advice. Okay, I have the honor now of introducing our panelists. We have Leslie Burkhoff of Morit Hock Hamroth. Okay, Leslie is a partner with the firm where she serves as chair of the firm's dispute resolution practice group and is former co-chair of the firm's creditors' right and restructuring department. Also joining us on the panel today is Liz Champnoy of Champnoy Dispute Resolution and Management Services, Inc. Liz is an attorney, consulting expert, independent full mediator, arbitrator, and trainer based in New York City with 25 years of experience in the field of alternative dispute resolution. And then we have Bjorn-Suk C. Of Snell and Wilmer. Okay, sorry. Bjorn-Suk is a business litigator who represents individual clients in complex intellectual property and commercial matters, and his clients have sought his guidance related to failed business ventures and disputes among business partners, shareholders, and directors. And my name again is Jeff Zano. I'm the vice president of the American Arbitration.
Uh-oh.
I'm sorry.
Uh-oh. Jeff, did you freeze?
Oh, I did?
Yeah.
Oh, he's back though.
You were just introducing yourself. You said American Arba, and then you
Oh,
cut
sorry.
off.
Okay. That's weird. My internet, is it fine now? Okay. So feel free to read more about our panelists on slides 32 through 36. This webinar is a production of Financial Poise. To sign up for their great weekly newsletter, go to financialpoise1word.com/subscribe/. Again, that's financialpoise1word.com/subscribe/ at the end. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise1word.com. Again, info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get you an answer. Okay, we'd like to thank our co-producer, the National Review. They're on slide 3. Second, I'll pull that up. Okay, and National Review has been around since 1888, and we want to thank them again for being a co-producer. Okay, so let's go to preparing for an arbitration. I'm going to take on the first slide, which shows the process. One second. The timeline, okay? The first step is filing and initiation, okay? Second part is arbitrator selection. Third part is preliminary hearing. And then the final thing in preparing for the timeline, information exchange. So I will now turn it over to, I believe, Liz, you're covering filing and initiation of a claim. You'll take that slide.
Yes.
Okay.
Sure. Thanks, Jeff.
Yep.
So to get to arbitration, you have to have either a written contract between the parties that says that in the event of a dispute, you'll go to arbitration, or you have to agree post-dispute that you and the other party are agreeable to go to arbitration. It's not like court where we can all just go file a claim in the court close to us, or where the dispute has taken place. In arbitration, you need either a contract or you need agreement of the parties to submit to arbitration. So at the start, to figure out, whether you're coming to arbitration, you've got to look to the contract usually, or agree with counsel. And there's two types of arbitration, so to speak, or two ways to arbitrate, if you will. You can arbitrate through an administrative agency like the AAA that will administer the claim and handle, all of the details for you, similar to maybe like a court or a court clerk. And Jeff, you'll jump in to say some more about that. Or you can do it ad hoc. And what that means is that you basically contact an arbitrator and you say, we want you to arbitrate this claim, and they essentially administer the claim from start to finish. I know people have different views about that. I feel very strongly that you should use an administrative provider. That's why they're there. There are a ton of benefits, and I'm sure my colleagues will add to what I'm saying in terms of why you should use a provider as opposed to using ad hoc, because you want sort of that middle person. You want a buffer between you and the arbitrator, who's the ultimate decision maker in any claim, and you don't want to be dealing with, let's say, for example, billing issues. If you have a question about the arbitrator's bill, and the arbitrator is basically the judge, the person who's going to make the decision, you don't want to be contacting them. You'd rather have somebody at the AAA or a different organization doing that sort of work for you.
Before Liz, I think a lot of people complain about or going to an institution because of the cost. But when you look at it, the cost for arbitration, it's only the institutions are about 5%. And the arbitrators are about 10%. So the cost factor is out the window, I think.
Right. And I would say to that, if you look at the cost, so let's say it's 5% for the administrative agency. If you don't have them doing it, whatever work they're doing is going to get done by the arbitrator. It's probably going to cost more, no disrespect to us, because it's going to be some hourly rate versus a calculated fee. So I think it's a misunderstanding of the economics, because nobody really says, well, if they don't do it, someone's still doing it and charging for it. But to your point, Liz, I think doing it without the administrative body is a mistake for a couple of reasons. Some of them you've already highlighted. The arbitrator is very limited in their interaction, not like a mediator. So we need that buffer. I don't want to be dealing with the parties about billing and fees and questions on bills. The other thing is, you have an issue, if there's an issue in a question of disclosure, if there's an issue in terms of guidance in process, you at least can talk to your case manager ex parte as a party, okay? Whereas you can't do that with the arbitrator. So you're missing that guiding force, that backstop. And again, things like, they don't come up as often, but the need for an emergency arbitrator, how are you dealing with that without the agency, with the administrator? And then to the extent there are limited appeal rights, again, there are benefits to having a structure in place to guide it. So when I've had these conversations with people, I think it comes from a place of, quite frankly, naivete. And if I can add one more thing, there has been a push occasionally to develop these ad hoc rules that are just supposed to exist in the ether to replace AAA or JAMS, and they completely miss the boat, because what they're missing is the fact that at the end of the day, how do you then get to court? How do you do all the other things? You're going to end back up in court because you've got nothing else to guide you or help you.
Yep, thumbs down.
So once you actually, if you go back for a second, once you decide you're going to arbitration, whether you've agreed or there's a contract, it's very simple to file a claim. Usually the contract will not say what organization it's through, like AAA. You would, look at the AAA's website, and you would basically file what's called a demand for arbitration. It's a simple form. You'd attach the arbitration agreement or the agreement between the parties to proceed in arbitration. And one point, I know we're going to talk about this in the next, they're basically what happens then once you file, Jeff, AAA acknowledges it, sends it to all the parties, and then gives a time to answer and respond. So pretty simple to file. You also pay your fee when you file your, demand for arbitration, and go from there. We can advance. Then we're going to talk about
everything can be done online nowadays.
So simple to do. One of the things we often talk about is, while it's very simple and you can just fill out a form, best practice is probably not to just fill out that form. Better to actually file, a real complaint, tell the story of what's happened here. So when you file a demand for arbitration, and you fill out the form, you just say, what's the nature of this dispute? You could say breach of contract. It has the parties, it has the amount in dispute, that sort of thing. If you're represented by counsel. But best practice, and I think others here will agree and chime in, that better to really lay out what the issues are, lay out the claim, tell the story. Because as we get further in the process, what you'll learn is that the arbitrator, when the arbitrator is contacted, gets that pleading, right? So if it's just that simple, form that says breach of contract and here are the parties, you're not using the opportunity to start informing the arbitrator, influencing the arbitrator, and sort of laying out what this case is about. You're waiting to do that later. Leslie, Beyonce,
Yeah.
other
If
thoughts?
I can chime in for a second. So look, on occasion, there's nothing horrendously wrong with filing a quick demand and then supplementing it, because sometimes that's, you need to do it that way. But what I have found is a couple of things. If you do not then file a real demand, you're sort of prejudicing in some respect the other side, who doesn't necessarily know what they're responding to. Therefore, you're constraining your pleadings, which is not helpful to the arbitrator. You are also maybe not informing or guiding discovery. So when I get to my preliminary hearing, if I got, 2 sentences, I don't even know what they're talking about, what it's about. We may miss things. And that's a bit of a problem as well. The other thing that I have seen bite someone in the, what, they filed a sole demand. We had a hearing, and at no point did they put a full claim in. Well, at some point, because they never really thought about what they were doing, they made a request in their post-hearing briefs for attorney's fees. It wasn't in their demand.
Yeah.
If it's no different, if it's not in your complaint, you don't get your relief. They missed that, and they missed something else because they never took the time to focus on what they had asked for. And they were completely boxed out from a time limitation and, quite frankly, a process. So you're hurting yourself. You really are. And again, the more educated an arbitrator is, the better it is, because we sometimes don't get pre-hearing briefs. So I'm going in blind to a hearing with a 2-sentence something, and I know nothing about what your claims are. And this is your chance to tell your story.
Yeah, and to touch on what Leslie's saying, if I get one of those simple form-based demands, that's usually the first thing I address at a preliminary hearing and say, hey, I think I want you to be supplemented anyways. Even if you didn't want to, I'm going to try to force you to do it on the other side. And the one thing I would also say is you don't necessarily, for the attorneys who are experienced in court litigation, but have maybe the younger attorneys who have not been in arbitration, just know that the demand doesn't have to be exactly like a complaint. So you can take a more narrative approach if you'd like, if that's easier for you, or if it makes sense for your case. Or you could take the same approach and essentially draft the equivalent of a complaint with each kind of standard one allegation per paragraph kind of approach with that. So you have a lot more flexibility. But if it makes more sense from a timely perspective and a narrative perspective, and you want to just craft essentially a story in a letter, you can do that as well.
And then the only thing I'd add, and I agree with everything you say, because sometimes you get it looking like a complaint. I don't really care. I almost prefer it more narrative because it tells a better story. But some of the rules, it's a little less important in an answer, to the extent as follows. If you're disagreeing with everything they say, you don't even have to file under some of the rules. It's deemed denied. It's if you have a counterclaim, or if you have a story to tell. And interestingly enough, in traditional litigation, you're a little constrained in how you answer a complaint, because you're just responding to the allegation. And absent a counterclaim, you don't get to really tell a story. It's, I agree with this, I accept that. You actually have that chance. And so sometimes I find it surprising that the other side is, I'm not putting in an answer, it's deemed denied. I get it. You don't agree, but don't you want to tell me your side of things? You're not equally constrained. So I think it's a missed opportunity.
Agree. So once you filed the demand and there's been an answer, the next step in the process is arbitrator selection. And usually the AAA, Jeff, don't let me step on your toes, has an administrative conference, case manager and counsel or the parties, to talk to them about, what type of arbitrator do you want, what type of background, experience, subject matter expertise, that sort of thing. And Jeff,
they
do you
really
want to
go into
talk?
details. Clients really go into detail. The attorneys go into really specific details. Wasn't always the case. When I started at the AAA many years ago, we didn't really have these administrative conferences. Now, for all of our cases over $1 million, the bigger cases, we have these conferences, and they're really successful. They're usually about 20 to 30 30 minutes, if not longer. And we do hear a lot from the clients and from the attorneys.
And Jeff, what do you hear? You hear, this, are they saying that we want the subject matter expert in, intellectual property? Are you hearing that they want big firm, small firm? Are they saying?
I never hear the big firm, small firm, but I hear more industry expertise. That's what I'm hearing. Like I need someone that has X amount of experience in the insurance business for 10 years or something like that. We don't really hear anything about the fee. A lot of people say, well, they question the fees. I don't want anybody under 500 or above 600 or whatever. I don't hear
If
that.
you're too cheap, they worry.
Yeah, I've heard that, but also I do hear, I want some judges sprinkled in there, that we do hear, but it's mostly about the industry expertise, I would say.
And so that means business people too, not just lawyers?
Well, 95% of our panel in the commercial area, if not more, is attorneys. So we do have some business people. We have accountants, we have engineers, and for the construction area, architects, but most of our arbitrators are attorneys.
So one thing, and Jeff, just to highlight a focus that we're on, the commercial financial services, that has become a big one. And I had a recent arbitration where the parties specific, because an issue came up, and they specifically said, we picked you because of your background, because I represent lending institutions. I understand the agreements. I understand financial transactions.
Sure.
And that was incredibly important to them because of the nature of their dispute. And I didn't ask, they basically said that was what we picked, why we got you and why we wanted you.
Absolutely. I hear that all the time.
Yeah.
And then when we have non-attorneys, Liz, your question, sometimes we have the wing arbitrators of the non-attorneys. For like a construction matter, you'll have an attorney as the chair, and the wing arbitrators are an engineer or an architect or something like that.
Yes. So there's what Jeff is referring to is, so you might have one arbitrator per the clause, per the rules, per the parties' agreement. Other times you can have three arbitrators and have different areas of expertise. Now, having three, adds some cost and some time, but sometimes people feel more comfortable with three because they need maybe three different people with three different areas of, subject matter expertise. Or sometimes, it's such a significant case or so complicated that people are worried to put it in the hands of one particular arbitrator, because if it goes bad, it goes bad. And groupthink, three people versus one, they might have a better shot of things being thought through better, or somebody catching a flawed argument or being more reasonable and so forth. So you can decide between, one and three. Any thoughts on that before?
I always try to encourage one, because it's 5 times more expensive to go with three, not 3 times more expensive, 5 times more expensive, and it takes about 6 months longer for an arbitration. But I think the issue about 1 versus 3 was an issue 25, 30 years ago. Okay, the rogue arbitrator. AAA ICDR 30 years ago had 56,000 people on our panel. 56,000. We now did a major purge in the 90s. We have about 5,800 arbitrators on our panel. So I'm not concerned about a rogue arbitrator. And that was
the only thing I would just highlight here, and there are, and I've been on both sides of it, there occasionally really is a case where the 3 is super helpful because it's incredibly complicated and just there's so much going on. It really does help to have groupthink. I've done them both ways. The one thing I just want to highlight is, even if your agreement says 3, because I've been stuck in a couple of cases, and that's not disrespect to my arbitrators, fellow arbitrators. It is simply the case didn't warrant 3. So I had great arbitrators with me, but it was so monetarily ridiculous. And the parties at no point, it's not for us to say, they're like, yep, it says 3. You have the right to deviate from that. So you end up with a $75,000 matter and 3 arbitrators. It's not effective and efficient. And, we do what we can sometimes to let the chair take lead, to have the others step back a little bit. But, parties should think about that. What you put in as a bootstrap should be rethought at the time of dispute.
One thing I just want to mention, because we're talking about now selecting the arbitrator, is that this is one of the most important, this is, from my perspective, the most important decision you're going to make in this process. And what I find interesting is that a lot of advocates sort of rush through it. They don't give thought to who, what type of background or what type of arbitrator they want. They just take what the AAA gives them or what the other side recommends. And then they don't spend a ton of time, really looking at the resumes, gathering intel on them, doing research, looking at what they've written, what panels they've spoken on, like this, to get their thoughts, their views. They don't ask other people for experiences they've had with them. And that is, I always say to when I'm talking to advocates, that's the biggest mistake that you're going to make. And you can't really recover from it. If you don't get the right arbitrator for your case, not one size fits all, right? Somebody could be right for one case, wrong for another, that at the end, you really won't get the best process and or the outcome because you haven't given thought to it. I think because litigators, and Beyonce, I'm interested in your thoughts on this. I think it's because lawyers, litigators are so used to just having a judge assigned that they don't, and that you don't get to pick the judge in a court, that they just figure like everybody's great. And like Jeff said, they've narrowed the panel, they're more selective and so on. But again, that doesn't mean that a certain arbitrator is best for your case. Beyonce, anything you want to add?
The one thing I want to add is that I always incorporate my clients in this decision-making process.
That's great.
Because one of the things that as an attorney, as a litigator, I'm trying to manage is clients who are not sophisticated or don't understand this process. If we have rulings that I typically can predict are made, most rulings by an arbitrator and judges, you can tell that they're well reasoned or not. But if you have a ruling that is not in your favor and your client is kind of complaining about the arbitrator's capricious ruling from their perspective, just a word of advice for attorneys: you can kind of minimize that by incorporating them in the selection process. And you, as the attorney, should be providing all of the factors that Leslie, Jeff, and Liz just raised, because that's kind of a way to avoid the potential situation, no matter which arbitrator you end up with a ruling that they don't like, they may not understand, and then they may complain to you as the attorney about the arbitrary selection.
And for the
I mean,
non-attorneys, that's a very good point. For the non-attorneys on here, you should be saying to your lawyer, presuming you're represented by somebody, that you want to be involved in that process.
Yeah.
I'm sorry, did I cut somebody off?
Yeah, no, two quick things to add to that, and Liz, you covered so much of it. Don't miss the opportunity, videos.
Yes.
The AAA has videos. I can't speak to, I'm assuming others do. And I went through, as an advocate, about a year ago, an arbitration where, aside from everything Liz said, we scoured the earth on these. We used a consultant, and we looked at the videos, and it was interesting because we had some people on paper that looked great. And when they videoed, and this wasn't about looks, but it was like they were asked questions on their view on discovery. It was very important to us. And the way they responded, which you really couldn't see on paper, we cut a couple of people off. We're like, we're not using them. We're not ranking these people. We're ranking them lower because what they said in the video may not have been in their resume because it was a different kind of question. And quite frankly, also some of just the way they appeared. And I'm thinking, you look like a hanging judge. I mean, or you don't look like someone that's relatable. And it's important because it was a human story. And they didn't come across as someone who we thought we could connect with. And that stuff just matters. So don't forget about that. I think that's really important. And the other thing is you can, with very tight constraints, interview arbitrators.
Yes.
You cannot ask case specific. So you can't say hypothetically, if you had this case, but you could, and I've been interviewed. Have you ever had cases involving these issues? That's a fair question. What is your experience? Have you ever decided a summary judgment motion, a dispositive motion? As long as they are what I'd call more factual-based questions as opposed to case-specific questions. And I find oftentimes, I've only been interviewed so many times, despite how many arbitrations I've handled, and I'm surprised people don't do it more.
Well, yeah, it drives me crazy that people don't do it. And we do put it in our initial letter that goes to the clients, but people don't read those initial letters and it's
Yep.
free. It's not, there's no additional cost for the AAA to get, we call it the enhanced arbitrator selection process, where we'd get 5 arbitrators and we'd go on a Zoom call and you can interview them. Something that you really have to take advantage of, I think. Beyond Suck, have you ever done that, the enhanced arbitrator selection process?
We have not, and mostly because it's been a long time I've used AAA, to be honest with you. In our jurisdiction, in the cases that I deal with, they're not in the construction field. They're more
Yep.
business disputes. And what I'm finding is the arbitration provisions are terrible, and they don't even identify an entity. Instead, they just say we're going to deal with arbitration. And in Colorado is fairly unique. The preferred, I would say, for amongst experienced litigators, the preferred organization is a local organization. So it's quite different here.
Different, yeah.
Yeah, outside of here. So I haven't used that function. I think, when did that function kick in, by the way?
The enhanced arbitrary selection
Yeah,
process
yeah,
many years ago.
yeah.
Just that
So it's
we
been
haven't.
a long
We're
time.
guilty of not advertising it.
Right.
The AAA doesn't advertise a lot of things, unfortunately, but it's existed for a long time. But it's not
Wow.
used that often, except for really large cases. No.
And Jeff, will you talk about sort of the listing process? Because it varies. You can use the enhanced selection. You can get access to the panel to
Sure,
look. Oftentimes the AAA puts out a list. You want to talk a little bit about
sure.
how that works real quick before we move
The
to the next?
The default method is we generate a list. AAA will listen to the parties on or the council on an administrative call, and then we'll generate the list of 15 for a tribunal of 3 or 10 for a single arbitrator. But we do like to encourage parties to be more creative, and you can be creative and deviate from the default of us generating a list. So we do have a link to our whole panel, and a lot of times we'll give that link to sophisticated counsel that really like arbitration. They know the arbitrators. They want to take a look at this link. We give them a complete link. Also, some parties do party appointed, where they come in and two arbitrators are already selected. AAA wasn't involved in it, and then we help them select the third arbitrator. So there's many ways of doing it, but we encourage people to be flexible. That's the beauty of the process. Like you said, Liz, at the beginning of this, the best part of this process is selecting your decision maker. It's amazing. So.
Yep.
All right, beyond suck, prelim hearings.
Yeah, as the slide notes a couple things, but I would probably start with the second bullet first. Pre-planning by advocates is important, and the way you do that is by knowing your ADR provisions and rules that apply, especially in the jurisdictions that you have, and also the customs. I just mentioned Colorado is fairly unique because in most jurisdictions, AAA and JAMS is the most popular. We have a local organization called JAG that seems to be more popular amongst commercial litigators in our jurisdiction in this state. And I want to touch on what's mentioned there at the bottom called gatekeeping motions. To prepare for the preliminary hearing, obviously you need to know the ADR provision and the rules that apply. But there are situations where you can file motions to determine whether it should even be in arbitration, and that's called arbitrability. Now, the case law has evolved to where most of those motions have to be decided by the arbitrators themselves. So, you can't really file them in court, but that's been a trend and a transition. And state courts may not have adopted it completely, but I know at the federal level, that's kind of the leaning that you have. But there are circumstances in which if the arbitration provision is deemed to have been induced by circumstances of fraud, then you can try to attack it in the court. So you kind of need to know these things to be prepared for a preliminary hearing, so you can discuss it and let the arbitrator or the opposing party know, hey, I think this needs to be addressed before we do any of these scheduling issues, or set the schedule for the rest of the pre-hearing process based on kind of the motions that you need to file, whether it's to dismiss certain claims in the statute of limitations, or to push it out and say we can't address this claim because it's not subject to the arbitration provision. And knowing the rules is the number one key. Going to the next slide, this is this is the most important factor for me, which is, and I deal with this like scheduling conferences in federal court. Even if I have a younger attorney addressing kind of the procedural matters at scheduling conference, I typically want to go and attend because it may be the first time that the judge sees us as litigators. So uh, the considerations I think about when I go to a scheduling conference in federal court is typically the approach I take at a preliminary hearing as well, which is this is the first time that, and parties typically don't get involved in the preliminary hearings. It's just attorneys who attend. Parties can always attend, but I can't think of too many situations where my client has participated in either a scheduling conference in federal court or a preliminary hearing because they understand it's mostly kind of procedural. So I usually
But
go in there.
we do it at AAA. We encourage it, but it
Yeah.
never happens. You're right. I don't see
Yeah,
Once or twice I've had it, but mostly not.
Yeah.
yeah, and that's understandable. I mean, the clients typically don't understand all of the factors that go into the arguments for procedures, but what credibility matters for anything, and that's no exception for arbitration. So I always try to consider, okay, what helps me establish credibility, or what's the risk of certain arguments that or issues I want to raise at preliminary injunction hearing that could harm my credibility as an attorney, and which at the end of the day may harm my clients. And the number one factor beside that is all arbitrators that I've had experience with have always been worried and concerned about efficiency in the process. So always keep that in mind as well.
And are these done via Zoom or telephone conference? And how long are they about approximately?
And it's typically done, in my experience, by either Zoom or telephone because deemed uh, uh, it's not deemed necessary to be to kind of look at your nonverbal communications, because I think most seasoned attorneys know the issues to address at a preliminary injunction hearing, and that's okay. It's I I wouldn't mind doing it in person, but it makes more sense just do by phone or Zoom.
On
Sure.
significant, I've seen a lot on very significant cases with multiple parties, multiple lawyers, where the arbitrators prefer and the counsel prefer to do it in person. Usually takes like a half day or so, but that's when it's really, complex. But remember, Jeff, back in the day, it was always phone. And
Yeah, it was
then
always
it
phone.
sort
Yep.
of became video conference and phone. And now with Zoom and Teams and all of that, I feel like the majority of them are done that way. People have gotten out of the habit of just using the phone and
Yeah.
No,
speaking.
no, you're absolutely right. I would say 100% almost 100% of our prelim hearings are done via Zoom. But during the pandemic, we did see clients joining in. That was the interesting thing about the
Oh,
pandemic. Is people were home, and I had one case where I had like 10 in-house counsel on the prelim call. So it
yeah.
was a really large case, but that would have never happened prior to the pandemic.
Yeah.
People
Yeah,
were home.
and most of my preliminary hearings do not last very long. Some of them are real efficient, less than 30 minutes, but on
Yeah.
average, I would say they're 30 minutes. And I would say currently, this is the one thing that I prefer by Zoom, even if you don't turn on your cameras, only because I can figure out who's talking and when they're done, so I don't accidentally cut them off. One of the
Oh, sure.
annoying things about telephone conferences that I used to not like is sometimes you think opposing counsel is done talking and you end up being rude and talking over them, or vice versa. And so
Or they
it's nice
say,
when you can do it by Zoom. Yeah.
or
That's a
they
great
don't
point.
say this is Liz speaking, that
Yeah.
kind of thing. And you're like, who was that? Like, and you don't want to ask who that was, because with different voices, you don't know everybody's voice. The thing I want to add about the preliminary hearing, I don't know if we're ready to move on, is that it's really important. It's the roadmap for the case. And arbitrators are trained to take it very seriously. And I think the mistake that advocates make or clients make is they come unprepared for it. I think the AAA or arbitrators themselves will send out like a letter or an email that says these are the topics we're going to discuss, be prepared, right? So that you have an opportunity to talk to your clients about it first and come prepared. It's not like some courts anyway that I have experience with, I'm guessing others would agree, where you just show up, you set a couple of dates, no big deal. this is really set in stone, right? This is the way the roadmap is going to work, and adjournments are not going to be readily granted easily. So you really want to spend the time to prepare for it and make sure you get what you want out of that hearing.
And what
Well-
I'll say, and I agree with you, because occasionally, and I had something recently, I had to issue a ruling on a discovery dispute, and one of the parties had really not thought about what we put into the preliminary hearing order and was looking for certain relief. And I'm like, wait a second, at the preliminary hearing, we were very clear about what the scope of discovery was. This is not something that changed, and you made a motion, you had a concession in terms of what you were doing. Now you're coming back and asking for something. This is our roadmap. I can't change this. It's not a changeable event because it wasn't something unforeseen. And, and completely, by the way, missed which law was controlling. We go over that, what rules, what law. And then, 3 months in the case later, you're trying to argue something else. That was set. It's done.
Yeah, and I want to touch on something, Leslie, that you mentioned before on another subject, which is the parties should understand that even though the ADR provision may say one thing, if you think given the case, it should be dealt differently, have a conversation pre-hearing with opposing counsel and say, hey, I know that we're supposed to have the right to do these kind of documents, but let's talk about only exchanging these and get this to trial because the amount at issue between us is $10,000,
Yeah.
Yeah, and so I would encourage, and just for the non-attorneys on this call or on this presentation, that's similar to just amending the agreement verbally. And so
Right.
if you
Yeah.
authorize your attorney to say, have that conversation, it may be even a more effective way to ensure that you don't overspend on arbitration that you have to have.
Right. And the PHO becomes then the agreement between the parties, and it then modifies things. For 2 seconds, I had one once where the attorneys did speak ahead of time. They sent me a proposed preliminary hearing order, and I looked at the case and I looked at the facts, and then I got this order in with 50 interrogatories, 18 deps. And so I got on and I said, counsel, maybe I'm missing something, and there's information you're going to share about what appeared to be a very simple breach of contract case. Because I've looked at your agreed upon discovery schedule, and you've picked absolutely every option the AAA had in the template. Like it was one from column, and none of it made sense because they selected everything, and some of them are in the alternative. And they said, well, we were just trying to get along. And I said, that's wonderful, but this makes no sense. We're not having 18 depositions. You don't need notices to admit, and you don't need 40 document demands, and then all of this other relief. So be thoughtful about it, even if you are being agreeable. But you have to be thoughtful about it. And I think it's so important to think about 2 things. You're in arbitration, it's not litigation. Some of the rules don't allow you to have free discovery. I mean, free form discovery. And again, if the parties agree and they want it, so be it. But think about the economics of the case. And then again, I had one where the parties insisted, they agreed on interrogatories, and I can't tell you how many hearings we had with them fighting over the interrogatories. And I said to them at the preliminary hearing, we told you this is a bad idea. You insisted. Now you're stuck, and all we're doing is having hearings fighting about what the interrogatories meant and what's responsive. And we told you should just produce, just have it, document production, and take your depositions.
Yeah, I will say my default position currently in arbitration is to think, okay, do we really need an interrogatory? Because I want to do 0. Because they're just an exercise, in my opinion, of attorneys just basically posturing throughout the whole thing, and it's just frustrating.
Yeah, I would agree with you, or at least a discrete set if you really think you need something.
Sure. Okay, so are we covered the preliminary hearing? Is that correct?
Yep.
Okay.
I believe
So
so.
we'll move on
And
to
you're
the
up to-
scheduling order. Leslie, that's you. You're up.
That's good. And some of this I've already covered, but let me be clear. So when you get the case conferences scheduled, AAA will send you sort of a list of things that'll be covered. In more complicated cases at time, I may ask and I may supplement and ask the case manager to send something as well to the parties. You should come prepared. Byung-Suk said it, Liz said it. Come prepared. Please understand your time frame. Please understand what you think about whether or not it's a documents-only desk arbitration, whether or not you want to have a hearing. And sometimes, quite frankly, you may not know, and that's okay. Maybe you want to say, and I'll raise this with parties, You may not be prepared to say that now. Maybe you want to go through discovery, and after discovery, we will revisit whether or not we're having hearings or a desk arbitration, because you may not know until you take the limited discovery, etc. But please be thoughtful about it. Please think about what you need and what you want, because I'm setting a schedule. And by the way, if you're setting a hearing, we're actually setting hearing dates. Now, sometimes they'll have to go back and, obviously talk to their clients, or maybe they've done some discussions and, they don't know my schedule, but maybe they know theirs. But once you box this in, it's two things I tell the parties. The hearing's the hearing. It's not really that much different than court. In certain instances, yes, we move it. We move it for good reasons, for good cause. It's a little disrespectful to treat it very lightly. But the other thing is, I sometimes say to people, a lot of arbitrators, good ones, we're busy. So I just moved one because it made sense given the discovery. But I told the parties, we're moving from August, we're going into September. I've got these dates. This is what I have for you. In other words, you're looking at next year, because I'm boxed out with so many other things if you need X number of days in a row. And again, the ones that need a longer amount of days, we have one, I'm going to be in Delaware for 2 weeks, consecutive. And it's a three-party panel. Takes a lot of time to get our schedules together.
Leslie, you mentioned desk arbitration.
Yeah.
Yeah, and so I'm just curious because I haven't had a chance to do one yet. Yeah, could you walk us through kind of your thoughts on
Sure.
that?
So the way I view it, the way you should view a desk arbitration, it's almost as if, but not quite, it's a motion, it's like a motion for summary judgment in terms of the fact, but you're not constrained by the same standard. You know what I'm saying? So in summary judgment, you have to review it under the summary judgment standards. Here, the consideration should be, I think my documents are very clear. I think I have, by way of an example, a very clear breach of contract. You owed me money. Here's my default. I can show you didn't pay. I'm going to give you everything on documents. I'm going to give you declarations from clients that are going to attest to it, because you still need evidence. Okay, you have to have something to speak to the document. But there's really no reason to hear a witness, because we all agree on the facts, and maybe it's a question of, does this constitute a breach under the agreement? Is this something that violated that statute? So in consumer cases, a fair amount even become that way, because you really are looking at very, very specific statutes where one party will even say, they don't have a claim under this. They can't show these basic elements, and the facts aren't changeable. They are what they are. It's a cost-effective way to do things. Again, it's as if you were moving for summary judgment, but again, not limited to the, there's no tribal issue, a fact and dispute. It's sort of inherent in the process. And it's something people should think about, because if you don't need to take testimony to reiterate what I could get in a declaration, it just moves things faster. But you got to know the case and you got to understand it, because otherwise you've just wasted a lot of time. Is that helpful? So let me see what I haven't covered here. So here you're going to get invoice. So just so you know, from the arbitrator's perspective, once I've had my preliminary hearing and I understand what the case is about, which is why it's so important to have demands and have information, AAA will say to me, please give us your estimated fees and expenses. Now, if I know it's going to be a desk arbitration, if maybe I don't know that, or I will give them what I think a range is. It's subject to change. It is an estimate. But if, I'll maybe put something in for potential discovery disputes. If we've talked about dispositive motions, which should be really constrained and rarely granted, that'll have to get factored in. And then this is where AAA does us the favor that we should be doing, which is before that first hearing, or before it gets submitted for a desk arbitration, AAA will make sure they schedule out the deposits, and that I don't go into a hearing without money in hand, because once you have my ruling and not paying us is just, it's a bad business policy. And you don't ever want to be in a position to hold up a decision because someone hasn't paid. So it's preferable to get it ahead of time, no different than a retainer. And then anything unused gets refunded.
How often do you see one party not paying? Like the weapons?
By the way, I'm issuing a ruling on that today. And an interesting question came up. We had one party not paying, They were the party against whom the claim was being brought, by the way. The first party only wanted to pay half the fees initially, and the other side just said, I'm not paying my share. The question became, well, we presented it to the claimant through AAA. Do you want to pay for the whole boat? At some point, there will be an award of fees, not saying you're going to win, not going to say you lose. That will be a portion. But if you want your relief, and the question got raised, well, does it look bad if the claimant pays all of your fees? Does that mean you're ruling for them? And I said, my ruling is going to be my ruling. And by the way, in some consumer institutional cases, the claimant has to pay the fees. But the flip side is, if one side doesn't get the opportunity to pay all the fees, you would have everybody preventing a decision by going, arbitration, great, I'm not paying my half, see you later. And then no decision gets rendered. So you can't box them out. There was an agreement that the parties agreed to, that this would be a joint process. If they renege on it, the other side should be able to fill the gap and make a request for fees. But I've had a couple of instances, and we try and hit it early on and say, I'm not going forward. I'm not, this is not free. You have to pay for this service.
Absolutely. I agree.
I've been on the defense, quote unquote, respondent side of arbitration where we haven't asserted counterclaims. And when the claimant didn't pay their fees, we just said, great, fine. We're not on the hook, so we don't care. I've also been on the claimant side where we did pay the full balance because we still needed a hearing because we wanted a judgment that we would enforce in court, and that was important to make it appeal proof. So those are just two things that I would ask practitioners to consider.
Absolutely.
And this is an area where institutions really help out, where we're the buffer. We talked about that earlier, comparing ad hoc to institutions. Okay, so Liz, additional key preliminary hearing issues to be covered at conference.
So we've talked about some of it. There'll be document exchange in terms of discovery, a discussion about, what you're going to exchange in terms of documents, interrogatories, hopefully not included in that. Oftentimes there's a discussion about if there are any disputes about discovery requests or productions, how that's going to be handled. So in a court, you serve the request, you respond, you have a lot of fights about it, and then you file motions with the court. In arbitration, arbitrators are going to want to streamline that process. They don't want you sending motion after motion or bringing every, dispute to them, because as we've talked about, this process should be streamlined, more efficient, more cost effective, and so forth. So there's usually a way in which you'll talk about, if there's any disputes, if they can't be resolved between counsel or the parties, you'll write a one-page letter, that kind of thing. We talked about interrogatories. We talked about, the arbitrator having ability to decide, like we were saying, if you can say you don't want interrogatories, that sort of thing. The good cause shown is what we talked about. I just didn't use those words. You'll talk about experts. If an expert is needed to testify about something. What else?
On the experts, I would just like to add that I get pretty persnickety at the hearings about the experts to say, this is one of my few cases in which I'd like to impose actual court rules on the standards of an expert and all of that, because I want to be able to present credible testimony. So for the experienced litigators out there, that they know what I'm talking about. For the younger attorneys, obviously in trial, you can challenge the credibility or the admissibility of expert testimony. I kind of like to pull that doctrine in a little bit, only because I'm always concerned that the experts proposed by the other side, never by us, but by the other side, may essentially present junk science, and I don't want that.
Liz, did we cover all this?
Yeah, I think so. We talked about motions, will you allow a motion, a discovery motion, a summary judgment motion? That'll be covered. I'm going backwards. The deadline for any amendments of the claim or counterclaim, that goes back to what Leslie was saying at the beginning. You might file a demand, you might amend it, but as the case starts to form, and as you're getting your discovery, things may change. And so there should be a timeline for which you amend your claim to make sure it conforms now to the evidence and the relief relief that you're seeking, information exchange, will there be motions or discovery practice disputes to the arbitrator? And then the direct exchange protocol. I would be interested in having Leslie and Jeff talk about that. The used to be you had to send everything to the AAA. AAA would then forward it to, the arbitrator. There was delay. People were upset. Advocates saying, why haven't I heard anything?
Yeah.
And then years ago, it kind of shifted to you can contact. So Jeff and Leslie, do you want to talk about that? Because there's
Well,
some.
yeah, it goes
Okay.
through right directly to the arbitrator, but they have to copy the institution. They have to copy AAA, and it's such a better method of doing things. And we encourage it on all cases because there could be delay, like you said, Liz. Maybe the case managers are handling anywhere between 50 to 80 cases, a lot of cases. So it's better if the arbitrator is doing the direct exchange. Leslie, do you do it a lot?
Yeah. So here's the thing. I do direct exchange in absolutely every case with one exception, if there is a pro se party. The only reason I will not do it with a pro se party is because I have had situations where pro se parties do not really understand that there cannot be ex parte communication, and they will unintentionally or intentionally send something only to me. So I don't want to be in a situation where I have some consumer who's sending me stuff and then I've got to figure out how to deal with it. So that's the only exception to the rule. If it was an in-house or something like that, I'd feel differently, but I'm talking about individual pro ses and consumer cases. And yes, I prefer direct. The case managers work hard, but it could take them a day and a half to get something to me. Whereas if I see it, then I can respond fairly quickly. And then the second thing is they have to upload everything to the web portal. I also tell them, you got to still email me. I don't want to be waiting to get a notification. If you want it in my hands and you want me to be on top of things and be prompt, because one of the things I do in my preliminary hearing orders, almost all of them, I tell people, don't go ahead and file any motions. If you're having a discovery dispute, send me an email. If you could do it jointly, great. But get me information. I will do my best to get on a conference call with you if you can educate me what the problem is, and let's avoid extra paperwork. If I need it, I'll need it. I'll let you know I need something. Other than that, reach out, and that's what this is supposed to be about as well, is to have access to quick relief justice decision making.
Absolutely. So Leslie, we're staying with you. I think you covered a lot of this already.
Yeah, let me just see. So, actually, just one or two things that I didn't cover on this. This is so sometimes, like I said, you may have pre-hearing memoranda, which is maybe the hearing is going to cover a discrete area of the law or something that is a little technical in nature. I do a lot in the SIM swaps and cybersecurity issues. So sometimes having a little bit more information can be helpful. So that's something to think about. And this would even, apply if we were doing motion practice. But whether or not it should be simultaneous or responsive, sometimes it is just helpful, depending on what it is, to have everybody submit one thing at one time and then a second set at a second time. So it's not who went first, who went second, who went last. I do have page guidelines more because it should set a framework. I don't want one person giving me 5 pages and one person giving me 500. Exhibits generally are not included. It is crazy. There are some arbitrators that have font sizes. I don't blame them because I don't want teeny tiny. And I don't want what we used to do in the appellate courts. We used to muck with the margins before they put all the rules in the font to get your page limit in. Make it easy for us. Honestly, sometimes I find, yes, I have Lexis, I have Westlaw, but if you're citing a couple of key cases, just attach them, make it easier, because otherwise I'm trying to find this case and sometimes they're not published, or I only have a Westlaw site and I can't get it off Lexis. It really is helpful to have that. It just should be easy. Let's go to next. Okay, so this is one of the things that can be in a preliminary hearing order, and I'll give you 2 different views of it. The preliminary hearing order, if we think we're having a hearing, is going to have a schedule for submitting stipulations of uncontested facts, your witness list, your exhibits, all of those kinds of things. And definitely, I'd love joint admission exhibits if you can get them. You can't always. It'll have all of that. On occasion, it is more helpful in certain cases to let them go through discovery, have some general deadlines, have a pre-hearing conference, because they may have a better handle at that point, that they may say, you know what, we've gone through discovery, we are comfortable, we'd like to be able to submit these two witnesses by declaration or direct dec with the right to cross. Some of that stuff comes out better after discovery, after they know if they need experts. In the much more complicated cases, or cases that are going to run for a full hearing, at some point, I will have a set of hearing guidelines. How we're doing this, who's going to be in the room? You know, are you sequestering the witnesses? How we're taking testimony? Am I using a chess clock? Who gets what? All of those things should get covered, if not in the initial preliminary hearing order, then at some point when you need to revisit things for your hearing, because you need to know how you're running your hearing, and your parties need to know what they're doing, and they need to know what you're looking for. Do I want a set of witness of exhibit books? Do I want things, you know, pre-marked? Whatever it might be, that's important. And finally, on the type of award, it's important to know, again, this is where your agreement might say X, the rules you're proceeding under may say Y, but the parties have the right to come back and ask for different types. There is, you know, a basic award, there's a concise award, and then there's a full reasoned. I tend to very rarely be very vanilla, because I still think if someone's winning and losing, there should be a little bit more than, I got this document, I looked at these papers, you win, you lose. I add a little bit more into it, at least what I looked at in the statute, what I looked at in the agreement. So that to me is a concise award, tends to be mine. But sometimes they want full reasoned. And beyond, so I know you have thoughts on this, so I'll give it to you in a second, but you're going to pay for that. And I just issued one in a case. It was a 45-page award, because it was also a week of trial, post-hearing briefs, and complicated issues with multiple causes of action. The parties were entitled to know why they were winning and losing, and what I took away from that hearing, so they can understand. They may not agree, and I'm sure some of them didn't like it, but at least they understood what I was saying, hopefully.
Yeah, as a litigator, the things that I think about when I'm making a recommendation, if we have the opportunity to propose different kinds of awards, when I look at we in our jurisdiction, we call them findings of facts and conclusions of law, the more extreme, detailed rulings. I don't prefer those. If the few times I prefer them is only when I want to posture for a potential appeal, and appeals, for all the attorneys out there, you know, appeals, the likelihood of success is very low. But you have a better chance of trying to dissect some of the legal issues that may have been misapplied to present you an appellate issue that has a chance on appeal. I have yet to get to that point and argue that, but I've had opposing counsel push for it. Most end up in the middle, because I think most parties, like Leslie says, prefer to have some sort of reasoning. But there are many times I'm pushing for the basic, simple ruling, because if depending on the situation, my client might either feel very confident about the case and just want to prevent appeals, or narrow the opportunity of appeals, and that category has very limited opportunities for appeals, even more so than the rest. But also, if my client doesn't care about, I shouldn't say doesn't care, but is willing to live with arbitration hearing and just end legal fees, that's the one I push for. And I've yet to have opposing party agree to that, because typically when I'm feeling good about a case and I'm pushing for that, they're wanting some basis to appeal, so they're pushing for the other extreme. So we typically land in the middle.
Right. We only have a few more minutes, guys, but Liz, do you want to cover any of this information exchange and prep?
I think we've talked about it. I think the biggest takeaway, and in our next program, we're going to talk about the actual hearing, you know, evidentiary hearing, and then more about the award, I think. But I think the biggest takeaway is, you know, all of these steps in the process, filing, selecting your arbitrator, going forward, you know, to the preliminary hearing and so forth, and setting up this process are all really key to having a successful outcome, and a process that, you know, you feel like you got a fair sort of shake and that you were prepared for. And to keep in mind that, you know, arbitration is streamlined, right? It's not supposed to be full-on litigation with every tool available in the courts. It's supposed to be less and so forth. And so when you approach this, you have to approach arbitration with sort of the arbitration arbitration hat, if you will, not the litigator hat, and use every possible option. You want to really tailor the process to meet your needs and do what's best. Leslie, Byansuk, other, because we talked about motion practice.
I
We
think
talked
we've
about,
to-
so we'll go to the
yeah.
key takeaways,
Yeah.
just to close it out with the key takeaways.
Yeah, let's
Yeah.
just jump to the third, to page 30, because I given the time.
Yep.
I always, just this, and I'll just end it with this. It's pretty self-evident statement, and especially given what we have all said during this presentation. But arbitration can be cost-effective and useful, but if you're treating it like litigation, not following some of the rules or the precedent on arbitration, you're going to end up not being satisfied with the process. So know the rules, know the clauses and the law dealing with arbitration, and you have a better chance of getting an effective, cost-efficient result for your client.
Great. Well, this concludes our webinar. Again, you guys were terrific. Thank you so much. And thank you for the audience for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. And we hope you will join us for our next webinar. And again, it's called Handling the Arbitration. Premieres on July 22nd. I'm not sure what time it is. I think it's around probably about the same time as this.
Probably midday.
Midday. But again, I want to thank all of you guys. You were terrific as always.
Thank you, everybody.
Take care. Be well.
Thank you.
Bye,
Bye.
all.